We have reached the appointed time and we have formed a quorum. Let's invite the administration team to join us.
得兩個啫嘛。
冇問題，因為你頭先話咗開會啦嘛。
哦，就已經完咗㗎啦。
係啦係啦，咁一般如果冇人話 call 有問題咧，就唔使處理。
OK。好啊，我哋開始。
Let's get started. Item 1, clause-by-clause examination of the bill. So we'll continue with the clause-by-clause examination, Chinese version. What is left to be dealt with is clauses 52 to 58. That's about the amendments to the stamp duties ordinance. That's on page C3302 of the Blue Bill and page 90 of the English version of the marked up copy. So can we invite the administration team to walk us through this? Before we start the clause-by-clause examination, let me briefly go through why we would like to amend the stamp duty ordinance under the USM mechanism that we propose. All stamp duty will continue to be collected by the HK, the Hong Kong X, through electronic form. That is no different from the existing practice, but then with regard to the over-the-counter charging of the duty, we propose to amend the stamp duty ordinance so that there would be additional arrangement with regard to the printing or the chopping of the paper, so that that would also allow for the over-the-counter or OTC transfer of the stocks. And without this arrangement, then we will have to prepare another piece of documentation so that that would be prepared for the stamping of the duty, and that would also be against the original intention of establishing this USM market, and I'll be explaining the details in a moment. So can I refer members to page 90 of the marked up copy with regard to the meaning of a stamp? There is a corresponding amendment. That's because we are going to introduce this 5AA3. That's why under 5AA is about the OTC transfer of USM, and that's the additional arrangement with regard to the payment of stamp duty. So we'll be giving you the details in due course. Any comments from members? Yes? Legal advisor? No? And then clause section 4 to the stamp duty ordinance. That's because of the 5AA and also 5AAB. This is a corresponding amendment. So we have the new clause 4.3b. It says that if the amount of the stamp duty imprinted on a contract note stamped under Section 5AA2 has not been paid to the collector in a manner provided by the arrangement approved under Section 5AA(b)(1), the contract note is deemed for the purposes of subsection 3 to be an instrument that is chargeable with a stamp duty and that is not duly stamped in respect of the duty. This is a corresponding amendment. Any comments from members? If not, please go on. Then on page 95 of the English version, we have a new 5AA. This is an additional provision on methods of stamping, sale or purchase of Hong Kong stock. But then this section only applies to a contract note if in certain circumstances, and these conditions have been set out under 5AAB. And then I'll be explaining the details when I come to 5AAB. And then for these notes, under subsection 3, the contract note will have to be stamped in accordance with the manner specified by the collector, including the amount of the stamp duty chargeable. And 2, there is a note to the effect that the amount of the chargeable stamp duty has been or will be paid in the manner provided by the arrangement. There are other provisions. For example, subsection 4 says that a contract note stamped under this will have to be treated as duly stamped with the amount of the stamp duty imprinted on the note and within the time for stamping the note. And 5 says that a person commits an offense if the person with intent to defraud the government imprints on the contract note the matters described in this section and without the authorization, and so on. Legal advisor. Chairman, I have no comment on the provision itself, but then on the Chinese drafting, I do have some comments to make with regard to 5AA 1B. It says that in respect of which the conditions in section 5AAB 2B are satisfied, but that with regard to the conditions in which the section has been satisfied, I think the Chinese version should be 該單句符合5AA 1、2, then that would be applicable, because the way it is drafted in Chinese is a bit cumbersome. Who is to respond to this? I'll invite Mr. Ng from the DFJ to respond. Thank you, legal advisor, for your question. The Chinese version has been drafted in response to the English version, in respect of which the conditions are satisfied. So it's not about the contract note being able to certify the condition directly. That's why, in order to ensure that both versions will tally, the Chinese version has been drafted in such a manner. And in drafting the Chinese version, that is also a common way of drafting. Any further comments from members? Chen Kiam-Lam. Chairman, I think the legal advisor's comment is valid. He has a point there, because if you look at the English and the Chinese version, given the fact that the Chinese version is a translation, while they are attempting to make the two versions look close, I think it's difficult to understand the Chinese version as it now stands. That's why, in drafting this piece of legislation, you will have to consider the perspective of the reader. You will have to make sure that he'll be able to understand it right away, instead of putting it in such a weird manner. It's not that it's not clear. It's just that it looks weird, because normally when we write Chinese, we won't write it this way. I understand that you're just doing it as a direct translation from the English. It still doesn't look good. I think it also applies to the drafting of other pieces of legislation or amendment to other pieces of legislation. You will have to see how you can improve on it. Despite the fact that according to the legal advisor's suggestion, I think even if we were to put it in the way as suggested by the legal advisor, it would not affect the meaning. So please do go back and think about it. See if you can come up with a better version. Yes, any further comments? All right, we can now move on. Next is 5AAB. It says that the contract note will have to comply with certain conditions as spelled out in subsection 2. And the contract note is a contract note which is not specified in 5AA, and that's about the stamp duty as arranged for under the Hong Kong X and also under Schedule 1, subsection 2, specified contract note. Well, for the relevant categories, is about the transaction in Hong Kong securities and futures, and then under 12 or under 19.1, these are the contract notes that have to be prepared. And with regard to the sale and purchase of such stocks under the USM rules, they will have to be conducted in accordance to those rules. And under the rules, an instrument of transfer is not required for the registration of the transfer. So this is the essence of 5AAB. It then goes on to say that the collector must not approve an arrangement under subsection 1 unless the arrangement provides for the duties of a person authorized by the collector for the purposes of discharging these duties. And the payment by an authorized person to the collector of the stamp duty chargeable on a specified contract notes that will be stamped under this section, and also the imprinting by an authorized person, blah blah blah. So for the rest, they are the corresponding provisions. And also for any authorized person, if he makes a false declaration, then he will be subject to a penalty at level 2, which is collectible by the collector, and which translates into $5,000, and this is collectible by the collector as a civil debt due to the government.
Last but not least, subsection 7. There are some definitions here. Purchase and sale. Purchase and sale mean a purchase or sale within the meaning of section 19. In other words, it is a transfer of property for consideration. It is also written that other than subsection 12, section 19, subsection 12 is about the loan of shares. But it does not include a purchase, the contract note of which is a contract note to which an agreement under section 5A relates. Well, this means it doesn't include the payment of stamp duty by Hong Kong X on the premises. Well, this is a broad construction. Can I ask if members have any views? Legal advisor. I have no questions, Chairman. Okay, we can carry on. 55. 55. It amends section 19 of stamp duty. We are adding 1G to it. Here it says, for the purposes of subsection 1, if the person who effects the sale or purchase of Hong Kong stock makes, in respect of the sale or purchase, a contract note to which section 5AA applies, and the contract note is stamped by the person under section 5AA2, the person is to be regarded as having also executed the contract note. This is a consequential amendment to 5AA. Any views? If not, 56. This amends section 58A of the Stamp Duty Ordinance. The another clause also amends 58B, so that the civil fines will also apply to 5AAB bracket 6. These are consequential amendments as well. Any views? If not, the next one, 57. It is also a consequential amendment to apply the relevant amendments because of 5AAB. Okay, if there are no other views, let's go into 58, the last one. Well, actually, I have already covered it. 58A and B are the same. Any views or comments, members? I think we are nearing the end of our scrutiny. But now we have to deal with matters arising from previous meetings. On the 17th of November 2014, members raised certain views, and the administration has already supplied a response paper. And that's CB 1462/01. Could the administration please now walk us through that paper? And we'll see what members might have to say. Thank you, Chairman. This paper sets out the administration's response to members' questions raised at the meeting on 17th of November 2014. One deputation said at a public hearing that the Hong Kong SCC and also the share registrars, what the roles will be in a USM market. In the paper, we have stated our response. I'd like to mention that this paper itself has been forwarded to the Hong Kong SCC and the share registrars, and they have agreed to the contents of this paper before it was issued. In simple terms, under the USM regime, the Hong Kong SCC will be the system operator, while the share registrar will continue to play the role of agent of issuers. Both have a role in keeping and maintaining the register of members. The register will be in two parts, one covering the paperless shares, and this will be maintained and kept by the Hong Kong SCC. Those held in paper form will be kept and maintained by the share registrar. At the same time, the share registrar will keep a complete record. Second point, the division of work between Hong Kong SCC and the share registrar with regard to corporate action services under the USM regime. They have got a consensus already on this one. The SCC will provide the USM system, and the share registrar, as I said, will act as an agent of issuers. So they will send communication to registered shareholders and also take their instructions. In future, Hong Kong SCC and the share registrars will continue to discuss the details of work, and we expect that in the latter half of the year, the SFC will consult the market on subsidiary legislation, and the details will be provided then. And then, subsidiary legislation to be made under the SFO, what will be included in the subsidiary legislation. In the process of scrutiny of this committee, we have discussed in detail the relevant empowering section, and that is 101 AAO. We have given the gist of that section in this paper. Last but not least, some members asked about margin financing under the USM regime. We have confirmed in this paper that there will be arrangements for enabling shares to be charged or mortgaged for margin financing and other purposes. The relevant information will be available when the SFC consults the market on the USM rules later this year. Okay, the administration has already explained the paper to us. Any views or comments? If not, we will now look at the CSAs. Those have been sent out to members already. That's in paper CB bracket 1462 stroke 14 to 15 bracket 03. And also views raised in our December meeting. That's in paper 462 bracket 02. The administration, can you now walk us through the CSAs proposed? Thank you, Chairman. The CSAs proposed cover 4 items, 2 of which are made in response to the assistant legal advisor's concerns or questions raised during the process of scrutiny. The other 2 are technical improvements. Number 1, Clause 1. This is about the commencement date of the ordinance. In 17.7, it will add the new 14 in order to provide new flexibility so that the commencement notice can be in different parts, even if it is under the same clause or section. This itself is a technical amendment. Now we want to propose an amendment so that the new section will come into operation on the day the ordinance comes into effect, so that we can make use of the flexibility provided by that section as early as possible. The amendment itself, let us look at the contents itself. Subject to subsection 3, this ordinance comes into operation on the day on which it is published in the Gazette. And subsection 3, it lists certain sections, including the company's ordinance and other consequential amendments. They will come into operation on a date to be appointed by the Secretary for Financial Services and the Treasury by notice published in the Gazette. As for the second part, for the SFO, we have already written that apart from section 17.7, this is what I said just now. This has to do with the new clause dictating the date of operation of subsidiary legislation. Legal advisor. Thank you, Chairman. Let's talk about drafting. Now you just want to advance the date of operation of section 17.7. Have you considered keeping the original drafting and then just say 17.7 will come into operation on the date of Gazetto? In other words, you just take out 17.7 as an exemption. I'd like to ask the DOJ, Ms. Hui, to answer. Thank you. We have considered that. We have indeed considered drafting it as you said, but in the first phase, we will also have to have the introduction, for example, coming into operation at the same time. Therefore, in the new bracket 2, we would try to use a general kind of expression. We use the words "this ordinance" subject to subsection 3. Then we can include the introduction, etc. I can give you an example. The commencement notice clause is also within the introduction. Members, do you have any comments on the proposed amendment by the administration? Mr. Dennis Kwok. Let me go to 2A, page 5. I can see, are we still on clause 1? Who can take the question? We are only on clause 1 of the bill, Mr. Kwok. We have not come to 2A. Okay, I'll reserve my question.
有其他議員有冇意見？
Other members, any comments?
好啊，咁啊，下一個政府繼續。
Next one, administration. Thank you, Chairman. Proposed Section 101 AAO in Clause 12. There are two amendments here. First, footnote 2. The CSA is proposed having reviewed the new Section 101 AAO2K. The SFC reviewed that section and has proposed this amendment. This is to extend the applicability of the section to brokers and custodians who, together with share registrars, fall under the definition of system participants in the bill, so that the rulemaking power under that provision can be used comprehensively to provide for the rights, duties, and liabilities of the system operator and all system participants. I can give you an example. We think that in the subsidiary legislation there may be a provision saying that if someone, according to the rules, can take instructions or receive information, then he should not be made to take up responsibility if he acts according to the rules and instructions. We may be writing that kind of provisions. So we think this enabling clause should be cast in a broader way so we have flexibility to handle such situations.
Dennis Kwok. Thank you, Chairman. Chairman, I'd like to know a bit more about 2 capital A. It says that the rules made under that subsection may prescribe to offences for contravention of the rules, blah, blah, blah. So my understanding is, so you're referring to the court function. What does that mean? What activities will be covered? I'm not too sure about it. So can you walk us through 2A first? Let me first explain what 2 capital A is all about. Well, the background to this is that when we scrutinize the bill, the ALA raised a concern, and back then the discussion was about this. When we scrutinized the bill about 152 of the company's ordinance, the ALA noted that there was a footnote to that provision with regard to the court, which acts under the USM regime. If there is any transfer of stocks, then with regard to that transfer, the court has the power to issue orders, and the note says that that rule will have to be referred to by the court, and the ALA was of the view that it was an important matter, and therefore there was a need to state it expressly for the court's powers. In this case, that's why under 101 AAO, we have now added this new subsection to capital A, which seeks to make explicit and put it beyond doubt the rules made by the SFC under the new section 101 AAO of SFO may provide for the making of applications to the court in respect of allotments and so on. And the situations referred to would include the application made to the court in respect of allotments, transfer, and transmissions, and for the court's powers on receiving such applications. So these are the specific situations that we can see for now. But then, for further clarity, we try to make it more flexible, so that that would also make explicit both 2 capital A, and B, so that with regard to the subsidiary legislation to be made by the SFC, it can also cover matters that relate or are incidental to matters described in Section 2 and 2AA. In other words, that would involve issues that can be dealt with by the court, and that would also describe the jurisdiction of the court in the matter. Is that right? Yes. Legal advisor? So that was a point that you had raised. So what's your comment on this? Thank you, Mr. Kwok, for raising the point. initially, when I raised this point, that was in the amendment to CO, for example, 633 is about the Court of First Instance power to revise the original decision. Usually, the court's powers would be spelled out in the principal legislation, but then in the note it says that is with regard to whether or not the CF, the Court of First Instance has the power to make an order for the payment or compensation made. The USM rules will have to be referred to. In other words, such powers have not been explicitly spelled out in the principal legislation. Instead, one will have to refer to the USM rules. But then, if you look at the USM rules, that is under Clause 12 of the bill, it has not specifically included the empowering legislation or empowering provisions for the court. That's why we suggest that under 12 there should be an explicit provision saying that the SFC has the power to make rules relating to the court's powers. Thank you. I can also add that with regard to the bill on the court's powers, we have consulted the judiciary's comments before we submitted that to the legislature. So that's a point that I'd like to add. All right. If there are no further questions, then we can now look at new Division 4A to be added to Part 4. Yes, for the Division 4A to be added to Part 4, well, in the scrutiny of the bill, thanks to the legal advisor who raised a question about the application of the electronic transaction ordinance. In fact, the purpose of that ordinance is to provide for the electronic transaction of any commodities which are not in paper form, and there is a provision under the ETO excluding the application of certain sections of the ordinance to certain pieces of legislation. But then under the stamp duty ordinance, there is a need to stamp the contract note and so on, and that's provided under the exclusion of Schedule 1. But then Schedule 1 also provide that the contract note would again be excluded. That's why when we look at the OTC contract note, there would also be a new arrangement in place. That's why we believe that for the OTC transaction and other transactions, the practice should be similar. That's why we try to amend Schedule 1 to the ETO so that the schedule itself is an exclusion list. And what we are trying to do here is that for the new stamping arrangement, again, that would again be excluded from the exclusion list. In other words, that can be applied to such arrangements so that they can do so in electronic form, and it can also be signed in electronic form. ALA, any comments or other suggestions? No, I don't. Comments from members? Okay, then we have already finished with the scrutiny of the bill. So when would the administration like to resume the second reading of the bill? Or can we have some suggestions? Thank you, Chairman. According to our understanding, some procedures have to be made. For example, the ALA will have to prepare a report to the House, and we have checked with the time frame. So the first instance would be the 18th of March, when we can resume the second reading debate, because we have the Chinese New Year holidays coming up, and that's why the earliest date would be the 28th of March. And if we want to have more room for maneuvering, we can also come back on the 25th of March. Any further suggestions? If not, then we will act in accordance with the proposed dates by the administration, i.e., we can resume the second reading debate on the 18th of March, and then we'll submit the report to the House on the 27th of February. Is that okay? All right. If no comment, then so be it. Thanks very much for coming. Mr. Jeffrey Lam, Chairman, I'd like to say that you have been highly efficient, and we can also see that the officials have been very expeditious in responding to the questions. Thank you for your support. We have now managed to finish with the scrutiny of the bill, and thanks very much, officials. Thank you. Meeting is now adjourned. Thank you.